The Fall Line is a deep dive true crime podcast focused on missing people, unsolved homicides, and unidentified persons whose cases have gotten little, if any, media attention. Over the past year, we've covered the victims of serial killer Samuel Little, the unsolved murder of 12-year-old Georgia Moses, and unidentified John and Jane Does. This September, we explored a forgotten and unsolved series of cold cases, the Atlanta Lovers Lane murders. The Fall Line digs deep, interviewing experts like forensic anthropologists, genetic genealogists, DNA experts, and the investigators who were closest to the crimes. Through narrative storytelling, primary and archival research, and expert and family interviews, The Fall Line introduces listeners to victims and survivors they've never heard of, and we explore the reasons why their cases were ignored in the first place. Look for new releases from The Fall Line on Wednesdays, wherever you listen to podcasts.
I'm Brett.
And I'm Alice.
And we are the Prosecutors. Today on the Prosecutors, we conclude our investigation into the murder of Carlos Ortiz and Tara Rosado. Hello, everybody, and welcome to this episode of The Prosecutors. I'm Brett, and I'm joined, as always, by my arresting co-host, Alice.
I saw what you did there, Brett. Good pun. Although, let's make it clear, I don't arrest anybody, but I do get the warrants to get people arrested.
It's like the beginning of Law and Order, you know, the justice system. I forget how it goes. Made up of two separate but equally important groups. I don't know. The police, who, whatever. Anyway.
I can't help you out there. I only know the dun-dun. That's all.
Dun-dun.
That's all I know.
Yeah, they got great music. Yeah. It's about as long as ours, too. Nobody ever complains about the Law and Order theme song. I'm just saying. Anyway, Alice is having some technical difficulties today.
I just figured it out, Brett. Okay, guys,
there you go.
I finally decided to buy a microphone stand because I am not great at this. And I could not figure out how the threading worked. And apparently it's very easy, and I just did it. Look at that,
congratulations.
Brett.
There you go. Look at that. I'm so proud of you, Alice. So proud of you. That just shows you this is going to be a great episode. We're off to a great start.
I've only been trying
solving her technical difficulties.
I've only been trying to screw in this microphone stand for the last 20 minutes. After, by the way, I threw away a piece of my computer into the trash, and my dear husband went dumpster diving. Quite literally, it was like the trash can was out at the street, and I texted him frantically because we were recording, and I said, "Please go into the trash can and dig out my computer piece." And he did, and he found it.
Our patrons buy Alice a new computer, and she throws it away.
I'm sorry, Brett. But
it's okay.
But it's here, and it's good.
Thank you to your husband.
He's the best.
Finding the most important piece and protecting your computer and the podcast. He saved the podcast equipment.
This entire episode is dedicated to my dear husband.
There you go. I agree with that. He's a good guy. So, we are back today talking about Carlos Ortiz and Tara Rosado. Gotta be, those of you who love the legal nerd stuff, we're going to be all about the legal nerd stuff today. So, buckle in for an exciting roller coaster ride of legal twists and turns. And we'll start off where we left off last time, where this Macaulay character, he's been arrested. They got all the witnesses lined up against him. They got all the evidence against him. It's going to be a straightforward trial. What could go wrong? And then everything gets complicated. A jailhouse informant comes forward. Eric Bama, roll tide, Lansford. And Bama said that he'd been in jail finishing up his sentence when Adrian's brother, remember we talked about Adrian a lot last week. Adrian was supposedly Macaulay's accomplice in this murder, and Adrian was going to be the star witness for the prosecution. He was the one who was going to put Macaulay behind bars for the rest of his life. But suddenly you have Bama show up, and Bama says that Adrian's brother, Christian, was brought in on drug charges while Bama was in jail, and wouldn't you know it, they ended up in the same cell. And, as seems to happen all the time, Christian confesses to his new best friend that it was him, not Macaulay, that killed Ortiz and Rosado. And this is a bombshell. It's a bombshell for the defense. It's a bombshell for the prosecution. And unlike so many cases we've heard, this is not kept under wraps. It's not kept silent. Nobody buries this. The prosecution tells the defense, we got a jailhouse informant. Now look, jailhouse informants are notoriously unreliable, and so many people who are in jail or prison for crimes they did not commit have been put there by jailhouse informants, and we've talked about them before. We've talked about all the reasons they can be unreliable. But Bama was unlike any jailhouse informant I think I have ever seen. First, despite the fact that he had a string of minor criminal charges, he possessed a security clearance that he used to work at the Turkey Point nuclear power plant. Now, maybe that says more about our security clearance system than it does about Bama, but either way, this is a guy who's got some pretty, significant trust placed in him to be someone who's trustworthy. Second, when he came forward, he had nothing to gain. He had less than a month left on his sentence to serve, and he was basically ready to walk out of jail. The prosecution couldn't do anything for him. There was nothing he could gain from this. He would have been smarter to keep this in his back pocket in case he ever needed it again. If he got arrested one day for some future charge, he could say, hey, well, I know something about a murder. You want to hear about it? But he didn't do that. He just came forward. And why did he come forward? Well, we talked about last time, those kids, and how the one good thing that came out of this case was that the kids were not harmed. Well, according to Bama, Christian had lamented the fact that he had not known about the children in the other room, saying that if they had come out, he would have killed them too. And here's what Bama said about that. Then he said, so he went over there and he shot them. And he said if the kids would have come out of the room, he would have shot them too. And that really got to me because that's just horrible. And he even did the little pow, pow, 2 shots. And I could see in his face, man, for me to be sitting here and driving in an uncomfortable van and stuff, telling you I know he did it. I'm just telling you, his face, the way he looked me dead in the eye, and he was gives me chills thinking about it.
That's a lot. And those of you who think, why would someone be confessing this in prison? I don't know. Sometimes people do just they want to talk. It's honestly a little bit boring in jail, right? There's not many people to talk to, but there's also street cred. You want to show others. So sometimes with the street cred, you might get some boasting. But this is not uncommon that we will hear these types of confessions. Now, this wasn't the only thing Lansford knew about. These details included that the victims were demanding $20,000 and a kilo of cocaine, not to reveal the Demblon's Macaulay drug trafficking, a detail not known to the public. And we knew that he was demanding money and drugs, but not how much. Remember, we've talked about hold back evidence in past episodes where the police may hold back some evidence just to kind of test the knowledge of someone who claims to have inside information. And this, again, was the amount of money and the amount of cocaine was not public knowledge. Lansford also knew that Christian shot both victims, that he went to the crime scene with another person. Now, Lansford thought the other person was probably Adrian, but acknowledged that Christian did not specifically say it was Adrian who went with him. Lansford also recalled Christian's statement that after the murders, he threw the weapon into a canal and the details of Adrian's plea deal. Now, according to Christian, Adrian was taking the hit for him and wouldn't serve much time once they framed Macaulay.
Which all makes sense, right? I mean, we talked about this before. Yeah, Adrian's pleading guilty. He already has a criminal record, so having a criminal record is not that big a deal. And because he's testifying against Macaulay in this murder case, he's getting a great deal, and he's not going to serve that much time. So he is taking a relatively minor hit, particularly if his brother is guilty of a double homicide. And really, other than serving a couple years in prison, both of them are getting off scot-free for that kind of crime.
The prosecution was unmoved by this kind of late-breaking news. But when the defense found out about this informant, it became the centerpiece of their case. But the question is it admissible? Brett, before we move on, I am so excited about one of our favorite sponsors, Green Chef. As you know, we are both so busy being full-time prosecutors, full-time podcasters, and also trying to raise two little ones who seem to always be hungry. Well, just today, I came in from a long day in court, and I only had 30 minutes to whip together a meal, and thanks to Green Chef, that was such a simple task. Today, I made the crispy southern chicken for my boys, and oh my goodness, everyone licked their plate clean. They were so excited and wanted more.
Yeah, Alice, I was over at a Halloween party, and somebody asked me, do you really like Green Chef as much as you say you do? And the answer is 100% yes. Green Chef has a meal plan for every healthy lifestyle. Keto, paleo, plant-powered diets, or even if you just want to have delicious but balanced dishes. Green Chef is the first USDA certified organic meal kit, so you can enjoy hand-picked organic veggies and premium proteins without having to worry about where it came from.
And Brett, it's so nice these days to get to avoid the long lines at the grocery store and get fresh premium ingredients delivered right to your door. And since Green Chef's ingredients are pre-proportioned, you'll actually be reducing food waste by at least 25%. And I know that we've also had the chance to work with HelloFresh. Great news. Green Chef is now owned by HelloFresh, and with a wider array of meal plans to choose from, there's something for everyone. I love switching between the brands, and now you all can enjoy both brands at a discount on us.
So all of you need to join us and join Green Chef. Go to greenchef.com/prosecutors125 and use code prosecutors125 to get $125 off, including free shipping. That's greenchef.com/prosecutors125. Use code prosecutors125 to get $125 off, including free shipping. And you'll know why Green Chef is the #1 meal kit for eating well. So the prosecution comes up and they try and keep this statement out, claiming it was hearsay. And that brings us to our legal education portion of the podcast. Let's talk about hearsay. We've talked about it briefly before. We're really going to dive into it today because this case turns almost completely on hearsay. Hearsay becomes the centerpiece of the case. And you can see already you have this really important confession. And the prosecution saying, sorry, it's not admissible because it's hearsay. So what is hearsay? I'm going to use the federal rules of evidence because really most states' rules of evidence are based on the federal rules, with the exception of California, which has its own sort of wonky thing that it does, which is more or less the same, but has some unusual differences, which aren't relevant here because we're in Florida. So this is pretty much going to be what Florida does as well. So what is hearsay? You've heard it 1,000 times. What is it? Very simple. It is a statement that the declarant, in this case, that would be Christian, the declarant does not make while testifying at the current trial or hearing. So Christian, it's an out-of-court statement, we like to say. So Christian said this out of court, not on the stand, not testifying, and a party offers this statement in evidence to prove the truth of the matter asserted. So Adrian, outside of court, said, I killed them, and the defense wants to offer it in court for the proposition that it was Christian, not Adrian, it was Christian that killed them. So Christian says, I killed them. The defense wants to put that statement in to prove that Christian killed them. The problem is, hearsay is not admissible. So that may seem really straightforward to you. It's hearsay. It's not admissible. What are we talking about? Well, the thing about hearsay, there are probably more exceptions to the hearsay rule than any other rule in the law. It is the most exception-riddled rule that you can imagine, to the extent I taught a evidence class last year, and literally half of the class was on hearsay because you just have to spend that much time on it.
And even now, whenever I go to court to trial, I have a cheat sheet that is on like 11 by 14 paper, very small font, listing out all the exceptions and the rules that it cites to. Like, it's the largest cheat sheet of all time.
I mean, you've got to have that. I mean, there are times when I sit around and think, how do you ever get anything in? Because everything seems like it's hearsay. Because, if you ask somebody a question and the reason they know that is because of hearsay, I mean, that can affect that question. It's just like, there are so many examples of how this can become important. Like you say, where was the defendant that day? Well, he went to the store, right? Well, you could object to that because how do they know he went to the store? Because he told them he went to the store, right? Which is hearsay because it's an out-of-court statement. What is it to prove that he went to the store? Fortunately, there's an exception for statements made by the party opponent. So the fact that, you're the prosecutor and you're trying to get that statement in, well, if the defendant said it, you're golden. It comes in. Here, remember, Christian is not a defendant. So that exception is not going to apply. And you have like this long list of exceptions. And the whole idea is, why do we not allow hearsay in? I think you probably sort of naturally understand that, but let's just talk about it. So you got somebody who's on the stand and they're saying, well, this other guy told me that this thing happened, right? Number one, you're basically playing a game of telephone now, right? We're not hearing from the guy. We're hearing what the guy told you and what you're now telling us, right? So there's automatically some
Lost in translation, as we all have, right? That's the whole game of telephone, is no matter how clearly you say something, there's interpretations, there's misunderstandings, there's literally mishearing. And the more kind of people it flows through, the more fraught it is for being kind of distorted.
Exactly. So that's the first reason, a very common sense reason. The second reason, you have a constitutional right to confront your accuser. So imagine that I'm going to testify that somebody else told me that you did it. That's what I'm going to testify. Well, John said that the defendant said he did it, right? Or John said that he saw the defendant do it. Well, the defense attorney can cross-examine me. And if he says, well, how did John know that? I don't know. Where was John? I don't know. Like, there's nothing I can say about John. He can't confront John. He should be able to have John up on that stand and go through all the reasons why he might be wrong. Those of you who've seen My Cousin Vinny is like the perfect legal movie.
We should maybe do an episode on it at some point.
We should totally do it. We're going to do that. We're going to do that eventually. We're going to do an episode on My Cousin Vinny. But you guys probably remember the first big moment in that when Vinny cross-examines the grits guy, right? And the grits guy says it had to be these guys because there was this very brief period of time, and I know that because I was making grits. And Vinny eviscerates his testimony on cross-examination by pointing out that there's no way he could have made grits in that short a period of time, right? Well, if it was just somebody else was like, grit guy told me that he knew it was them because it only took 5 minutes. I mean, Vinny could do the whole song and dance with grits, and the guy could be like, I don't know, maybe they were instant, maybe he'd already cooked them some, maybe they're leftover, I don't know, right? Like, he doesn't get the opportunity to confront the person who's really bringing forward this information, and you have a constitutional right to that. You have a constitutional right to confront your accuser. Sort of a subcategory of that is just the reliability of the information. Under certain circumstances, information from another person might be reliable. So imagine this. You're standing on the corner and you're not looking in the street, but there's a car wreck, right? There's a big car wreck and you look over and the person next to you screams, "Oh my goodness, that truck just ran the red light," right? And then they disappear into the crowd and they're gone forever. And then the person who was hit by the truck sues. And they want to prove that the person in the truck was liable. Now they're suing, so they actually don't have a right. They don't have a confrontation clause right. So you don't have to worry about the confrontation clause because that's just a criminal thing. That's only in criminal trials. It's not in civil trials. So you're in a civil trial now. So you don't have to worry about that. So that statement can come in. But the owner of the truck's going to say, well, that's hearsay because the person who said that, they're not here. They can't testify about it. So this guy, he can't testify that this person said that. But there's an exception for what we call excited utterances. This is just one of many exceptions because the idea is that person is in an excited state. There's also present sense impressions. So there's two that fit here. They're in an excited state and they're saying what they just saw happen. They haven't had time to lie. They haven't had time to forget what happened. They're excited, so they're not even thinking about lying. They are just literally saying what they saw. So that seems like a statement that is inherently believable. It's a statement you can trust. So even though we can't hear from that person, the fact that they said that in those circumstances, we're not going to keep that out. You get to testify about that because we don't care about you. You're going to be cross-examined. You know, the guy who cross-examines you, he can talk about your memory and whether you heard correctly, how close you were to this person. Are you sure they said the truck? Are you sure they said they ran the red light? Like, they can cross-examine you, so we're not worried about you. It's all about whether or not the statement you're trying to bring in is itself reliable, if it has sort of the air of truth about it or not. And that's what all these exceptions are about. So it's things like what's written in a family Bible. So 100 years ago, great-grandpa wrote in the family Bible that his son was John. Well, we assume that great-grandpa would not have lied in the Bible. So if you're trying to prove that great-grandpa's son was John, you can use the Bible to prove that because we've decided you wouldn't lie about that. Records that are kept in the ordinary course of business. So records that you keep every day without even thinking about it. That's technically hearsay, right? It's a statement made outside of the courtroom, in this case in writing, for the truth of the matter asserted, but because it's kept every day, it's not the kind of thing you would forge, you can bring that in. Now, on the other hand, like a report made after an accident, that is not going to be admissible because that's the kind of thing that you might be thinking about the litigation that's coming down the road, and so you might fudge the report. It's not a regularly kept thing, right? So you can see the difference there. Why on the one hand, one comes in, on the other hand, it doesn't. Like I said, this takes up like half an evidence class going through all this stuff. So we're not going to go through all of it, but we wanted you guys to have sort of a general idea of the kind of things that would allow something to come in. So let's come back to this case.
And can I just say though, Brett, that your class must be so fun. I really do mean that. You guys, everything Brett just taught you is, I know the word hearsay is thrown out there all the time, kind of in common vernacular, but what Brett explained is so clear and it's so helpful. So you guys get to go educate your friends now whenever they, kind of yell out, it's hearsay. You can be like, well, it's actually an excited utterance, so there's an exception. But maybe don't do it because you might lose friends.
And, the first question is it even hearsay, right? Because the whole, truth of the matter asserted thing matters.
Truth of the matter asserted.
Yeah. So, let's say it's What did you think? What did you think he was doing that night? I thought he went to the club. Why'd you think he went to the club? He told me he was going to the club, right? That's not hearsay because we don't care whether he went to the club or not. That's not the point, at least in this circumstance. It's to prove what you thought. So you thought he went to the club because he told you he went to the club, but it's not for the truth of the matter asserted. It's for your own views. Right. So, that wouldn't even be hearsay. You don't have to worry about an exception. But here, this is very clearly hearsay. There is no question that Christian made a statement outside of court that you're trying to introduce for the truth of the matter asserted, so you're going to need an exception. Well, one of the exceptions we haven't talked about is that when a person is unavailable to testify. So, and this is a gateway. You actually got to have two. But the first part is, are they unavailable to testify? So Christian is unavailable to testify. And why is he unavailable to testify? Because he would plead the Fifth Amendment if he's asked if he murdered someone and confessed to it. He's not going to answer that question. He is going to take the Fifth Amendment. If you guys remember when we did the Derek Chauvin case, and there was an individual who had been with George Floyd that day, who the defense was arguing had provided George Floyd with drugs, with fentanyl. And the defense wanted to call him, and they wanted to ask him questions about this. And his lawyer came in and said, look, if he says yes, then he's on the hook for drug dealing and for third-degree murder. So he clearly has the right to assert his Fifth Amendment, and he's doing so. And at the end of the day, he was not forced to testify. He was allowed properly to invoke his Fifth Amendment rights. He wasn't able to testify. And that means he's unavailable. So he's unavailable. But that's not enough. You can't just say, well, he's unavailable, so the statement comes in. There's then a list of exceptions which only apply when the person is unavailable. And one of those is a statement against penal interest. So the idea is you wouldn't typically say something that would put you in jail unless it were true. So you wouldn't tell somebody, I murdered somebody, unless it were true. Now, you actually can imagine all sorts of reasons you would do that. Alice just talked about some. The same reasons that you might tell somebody in your jail cell what you did also might be reasons you'd lie about it. So you want to build a street cred. You want people to think you're a badass. You want people to leave you alone. So you're saying, yeah, I killed all these people, right? And that's why you can't actually use this exception just for any statement. You first have to have that unavailability. So it's like we get that these statements are a little less credible than like the excited utterance is, but since you're unavailable and there's no other way to get this information in, if it's something that would be against your interest, we're going to let it in. And so this confession fits that criteria perfectly. If there's anything worse than confessing to a double murder, I don't know what it is. It was certainly against penal interest. And the prosecution, despite the fact they tried to keep this out, they eventually lost. And with that victory in hand, the defense, they go into this trial, and in their opening statement, they hammer this. They say, you're going to hear from a very credible witness, and they're going to tell you exactly who committed this crime. They're going to tell you exactly who murdered Carlos and Tara, and it is not the defendant. It is not Macaulay. It's going to be this other guy. And that's what they say they're going to do, and then everything goes sideways. Alice, before we move on, I want to talk about one of our favorite sponsors, Warby Parker. Warby Parker was founded with a rebellious spirit and a lofty goal: create boutique quality eyewear at a revolutionary price point, offering eyeglasses, sunglasses, contact lenses, and eye exams. Warby Parker is committed to providing exceptional vision care online and in stores.
That's right, Brett. Don't let your FSA or HSA dollars go to waste. Put them to good use on Warby Parker prescription glasses, prescription sunglasses, contact lenses, and eye exams. Warby Parker is committed to providing exceptional vision care online and in stores, offering eyeglasses, sunglasses, eye exams, and contact lenses. And this is great. Glasses start at just $95, including prescription lenses. I've worn glasses my whole life and know this is an incredible deal. So try Warby Parker's free home try-on program. Order 5 pairs of glasses to try at home for free for 5 days. There's no obligation to buy. Ships free and includes a prepaid return shipping label.
That's right, Alice. And we did the home try-on experience. And today, my pair of Warby Parker sunglasses, the Raiders, arrived. You guys will see me wearing those maybe on a Get Vocal sometime in the future. So if you're interested in trying out Warby Parker for free, go to warbyparker.com/TP and you can try your 5 pairs of glasses. We can't wait to hear what you think.
The day that he was supposed to testify, Lansford refused to testify because someone had threatened to kill him if he did. Given the people he was dealing with, this was not an idle threat. Now, we have seen this before. Depending on what jurisdiction you're in, there are witness protection programs, but you can't always control the threats that your witness is hearing. You can't get to them to protect them, right? There's only so much you can keep these threats from them. And obviously, Lansford is about to testify about someone who claims and he believes killed 2 people and would have killed more if those kids had walked out. The prosecution again moved to suppress the confession, but this time they were in a much better position. Now they had hearsay within hearsay. You might be thinking, what? That seems made up. So, Brett, evidence teacher, give a quick blurb on hearsay within hearsay.
Yeah, I mean, it's really the same thing we've been talking about. So you're in a situation where you have a statement made outside the court for the truth of the matter asserted. So that's hearsay. Now imagine that the person who told you that statement is also outside the courtroom. So here, in this case, you have you have Christian, and Christian makes this statement, and Christian says, I killed these people. That's going to be hearsay. And he tells it to Bama Lansford. And now Bama Lansford's going to testify. Well, once Bama can't testify, now you have his hearsay statement. His hearsay statement is, I heard this guy confess. So it's so he tells, let's just imagine it was the police. He tells the police officer, I heard this guy confess. And he said he killed these people. So that's his out-of-court statement, right? And his out-of-court statement is he's telling hearsay to this police officer. Now he's not going to testify. So now you would have to have the police officer get on the stand and say, this guy told me that this guy told him that he killed somebody. So it's hearsay within hearsay, in which case you need an exception for both. So, imagine a circumstance in which, I don't even know what a good example is. Okay, so imagine it was a circumstance in which he was the defendant. So he's the defendant, and he tells the police, this other guy said X. So he's now told them something that's hearsay, what the other guy said. He then doesn't testify because he ends up being the defendant, right? So he's not going to testify against himself, and he doesn't have to testify against himself. So now his statement he told the police is hearsay, and what he told them is hearsay. In that case, you have the hearsay exception you have here, where Christians said that he did something, that he murdered somebody. He's not available, so you have a hearsay exception for him. And the other statement that Christian said that is by the defendant, and there's a hearsay exception for that. So then you have 2 exceptions for both statements, and you could testify to hearsay within hearsay. Unfortunately, in this case, there really isn't any exception for the statement made by Bama Lansford. Bama Lansford, he's now unavailable, right? I mean, he said somebody tried to kill him. And let's talk about what these exceptions are, because you might think, well, that seems That seems like that should be enough, right? I mean, somebody said they'd kill the guy. Surely that doesn't just mean the statement doesn't come in. And actually, there is an exception for that. If you are the person, if the statement would be harmful to you and you're the reason the person can't appear, in that case, the statement can be used. So if you're the mob and you tell somebody, we will murder you and your family if you testify, and the police can prove that, that's a circumstance in which you could bring that statement in. The problem here is, Lansford, he's saying that somebody threatened to kill him, but we don't know who that is, right? And he's a defense witness, not a prosecution witness. So it's not even clear, who is this statement against? I mean, it's against a non-party, right? So you've got this sort of weird situation where you have a guy who has told you something that seems really important, but all of a sudden, he's nowhere to be found. So what are you going to do?
Are you asking me?
Well, I was just
I'm just kidding.
If you wanted to go on
I'm
with
just
that.
kidding. I'm just kidding. All I have to say, Brett, is maybe instead of being, a podcaster, you should be a full-time professor. You're really good at this. But anyways, okay, let's go back to, now that we kind of had this good mini lesson in hearsay within a hearsay, let's go back to what happened in this case. Kind of like what Brett has said, the reason this is hearsay within hearsay is because not only was Christian's statement hearsay, but Lansford's statement relating it was hearsay as well. The defense would need to call a witness to testify that Lansford told him that Christian told him, hence the hearsay within hearsay. Ultimately, the judge decided to exclude the testimony, so the prosecution, in an act of hubris, hammered the defense in closing for not producing the witness in trial that they had promised in their opening. Let me tell you something. We've said this many times before. Whatever you promise in an opening, you have got to deliver. Otherwise, it is a very, very blatant thing for the other side to hammer you for being basically dishonest and not being able to deliver if you cannot deliver what you said in your opening. So typically, you are supposed to only promise the type of evidence and the evidence that you know for a fact will come in. Now, this is kind of not very nice of the prosecution to hammer them because the judge had initially allowed this testimony to come in. And so I would say the defense had a good faith basis to believe that they could talk about this in their opening statement because the judge had said, sure, this testimony can come in. I don't think any of them had envisioned that Lansford would get a threat the day of to then create this hearsay within a hearsay problem.
And Aloes, I feel like we see this so often because trials and just the legal practice in general, trials don't happen as much as people think they do. I mean, a lot of it really is just sort of all the pretrial stuff and fighting between the lawyers and all the little things you don't see and never show up on Law and Order. It can be very emotional, and it can get personal. Like, you can get in a position where you really don't like the defense and they really don't like you. And, that danger of wanting to win at all costs can be a problem. And I just can't tell you the number of times I do a lot of appellate work, as I've said before. So, a lot of times if something goes wrong in the trial court, eventually I'm going to have to deal with it. I'm going to have to figure out a way to try and preserve whatever happened, right? And sometimes people will come to me and they'll ask whether or not they should do X, Y, or Z. And a lot of times I'll be like, do you need to do that? Do you have to do that? Is it necessary to do it? Because if it's not, maybe the downside outweighs the positive. And sometimes I think you have to use your judgment and say, we have an overwhelming case here. Maybe we shouldn't go that far. And here in this case, yeah, the defense said they were going to do this. They were going to introduce this. Like Alice said, they had a good faith basis to believe that until the witness doesn't show up. And they didn't do it. You can bet the jury's going to remember that without you mentioning it, number one. Number two, now, as the prosecution, your case really is overwhelming. I mean, you've got the text messages, you've got the eyewitness accounts, you've got the gun, you've got the phone, you've got the pictures. You have so much. Do you really even need to mention this? Is this something you need to do? And yet, the prosecution does it anyway.
Right. I mean, just like on the field, you're not supposed to spike the ball. Same with being an attorney, and I think especially being the prosecution. Um, it is not a good look. Often jurors don't like that either. They don't like seeing, the prosecution or either side really beat up on the other side, but especially the prosecution because of the power, that we hold, that we're bringing these charges against um, against someone, and it will have, lasting ramifications on their life. So I personally don't like this, nor do I practice like this, but it happens, certainly. And unsurprisingly, because of all this overwhelming evidence and, without Lansford's testimony, the jury convicted Macaulay. The prosecution might have crowed about keeping Christian's testimony out, but now the defense would make them eat it. Macaulay appealed his conviction, and he won.
Can we just stop there for a second? Because you never win, right? Like, we talk about these appeals all the time, and nobody ever wins an appeal. But Macaulay did. He won his appeal. He had his double murder, double life sentence conviction overturned by an appeals court.
That's amazing. I mean, I know all of you are now on the edge of your seat as to how that could be, because there was overwhelming evidence at the trial level. First, the appellate court found that this was not harmless error to keep out Lansford's testimony. If the district court incorrectly kept out the testimony, it certainly hurt the defense's case, obviously here. This was made obvious by the fact the prosecution highlighted the failure of the defense to produce the testimony during its closing. They shouldn't have spiked that ball.
Wah, wah.
Seriously, when you do stuff like this, it will come back to you.
And look, we've talked about harmless error 1,000 times. I mean, every time we talk about cases, we've been on with Maggie Freeling on her show a bunch of times, and there are often errors that she'll find in cases, and she'll always ask us, well, why didn't this error matter? We talked about this in the murder and alliance stuff. Why didn't the fact that prosecution didn't turn over that piece of evidence, why didn't it matter? And harmless error is almost always the answer. That even if it was a mistake, it was harmless because it was relatively minor and it didn't really matter, and maybe they should have done the other thing, but we're not going to vacate this conviction just because a mistake was made. You have to prove it matters. You have to prove it did harm. And here, this is a case where it did, where the court says, look, if you got this wrong, that was a big deal because the defense's entire defense was based on this. Everything they were going to do was based on the idea that somebody was going to come in and testify that somebody else did it. That was their defense. And you know why? You know how we know this is important? Because the prosecution spent half their closing talking about that this person never showed up, right? And so, once you lose harmless error, then you're in a world of hurt because a lot of times, like we've said before, there are mistakes made in every case. And if you can get past that harmless error barrier, if you can get past that, then you're in pretty good shape.
And then secondly, the court found it was error to keep out the testimony. The court pointed out that the state relied heavily on and was on strong ground when it cited the rules of evidence. But unfortunately for the state, the court noted these were, quote, the very rules that decisions of the Supreme Court subordinate to the defendant's constitutional rights of due process and confrontation. In other words, rules are not going to get in the way of your constitutional rights.
Yeah, and the trial court, it got so wrapped up in the rules, and we spent a lot of time talking about the rules. And the trial court was absolutely right. Like, if you just look at the hearsay rules, he got it right. I mean, there's some wiggle room. If there weren't enough exceptions, there is a catch-all at the end, a catch-all exception at the end, which basically says if it's otherwise believable and it's important, it can come in under the general exception to hearsay.
And that's just because these rules are meant to help us not that it's a game, but so that everyone's on equal footing, right? But at the end of the day, I mean, equity comes in so often whenever you find court decisions that overturn or kind of if it was the right decision based on the rules, but equity doesn't sit well, there's no justice there. That's what the courts turn to because ultimately these rules are meant to protect our constitutional rights and liberties.
Exactly. And they certainly don't take precedence over them. And another thing, these rules are supposed to apply equally to the defense and the prosecution. But the reality of it is, at the end of the day, the defense is at a disadvantage. The prosecution's bringing the case. The prosecution automatically has sort of the imprimatur of the state. And a lot of times the defense doesn't have a lot of evidence. And they're just at a disadvantage in a lot of ways. And so while the rules are supposed to apply equally, they oftentimes don't. I mean, the defense gets a little bit more wiggle room. And here, doubly so, because they have these constitutional rights to due process. And what the court's essentially saying is, look, this statement would never come in if it was the prosecution trying to bring it in to prosecute somebody. That would never come in under those circumstances. You would never allow a double hearsay out of court statement to come in to convict a defendant. That flies in the face of every right you have. But in this case, that's not why it's coming in. In this case, it's coming in as part of his defense. And since it was the heart of his defense, and, the court looked at the same things we talked about. The fact that this particular jailhouse informant seemed pretty credible. The fact that he told this to the prosecution and, in fact, was cross-examined in the prosecutor's office about it. So the prosecution had plenty of opportunity to walk through this guy's testimony with him. All of those things meant that the jury should have been able to consider it. Now, maybe the jury rejects it. The prosecution certainly could argue, you didn't hear from that guy. They're basing this all on somebody who didn't even show up. They could certainly say that, but the jury needed to know about that statement. They certainly needed to know about it because the prosecution made a big deal about it in their closing. And the court concluded, if a confession by a third party is critical evidence that should have been admitted in evidence to protect the constitutional rights of the accused, the particular reason for excluding it under state law will make little difference. So, yeah, okay, fine. You got the rules of evidence right, but guess what? You lose under the Constitution. And just to make itself clear, the court's last sentence before reversing the conviction was this: trial lawyers well know the effect on jurors of an unfulfilled promise to deliver a material element of proof, and the state hammered home that unfulfilled promise as it delivered its closing argument against Macaulay.
Brett, before we move on, I'd love to talk about one of our wonderful sponsors, PDS Debt. How many of you wish there was a better solution to paying off your debt? Our sponsor, PDS Debt, has customized debt slashing options for credit cards, personal or student loans, medical bills, collections, or any other type of debt. We spoke with the owners at PDS Debt who let us know that because of COVID-19, now is the best time to take advantage of options to get out of debt.
And Alice, it's no surprise that so many people have been struggling with debt during the pandemic, and you may qualify for programs where certain debts can be reduced or completely eliminated from your credit report. Don't put it off, and don't wait for these debt canceling programs to no longer be available. It takes less than 60 seconds to go to pdsdebt.com/TP and find out how to resolve your debt now. 5 simple questions will get you a free credit report and a proven plan to become debt-free.
And there's really nothing to lose. The worst case scenario is you walk away with a free credit report and better understanding of how to get rid of your debt. So if you're making payments every month on your debt and your balances aren't going down, this program is for you. PDS Debt rolls all of your payments into one low 0% interest monthly payment. There's no minimum credit score required. Bad and fair credit are accepted. and you'll save thousands in interest and fees. So pay off your debt in a fraction of the time.
And if that sounds like something you could use, PDS Debt is offering a free debt savings plan and credit report just for completing the quick and easy debt assessment at www.pdsdebt.com/TP. That's pdsdebt.com/TP. Take back your financial freedom today by visiting pdsdebt.com/TP. So, the prosecution was really taken to task in this case. Would it have been different if the prosecution had not done that? If they had left that out, Macaulay might still have won because this was still a really important piece of evidence. But by doing what they did, they made it inevitable. They made the fact they were going to have to retry this double murder case inevitable. And we talked about before the effect of bringing in an outside prosecutor and how this prosecutor, they were going to try this case and then leave. And what effect would that have on sort of them mentally, not being part of the community, not having to reappear in front of these judges or in these courts again. And I kind of feel like the fact that they were essentially hired guns led them to be more reckless and to do things that they might not have done in their home courtroom. And that includes taking this tactic and applying it in court, and they just got slammed for it. So, as of this recording, Macaulay is still awaiting a new trial, and many wonder whether the state has made a huge mistake in accepting Adrian's story at face value. Now you have this situation where you have two people who are dead, and they were killed execution style. And you have to wonder, are they ever going to get justice? Because you think about what's going to happen in that trial. Whether or not Bama comes back from Bama to testify in the Key West case or not, his testimony is going to come in. And the jury is going to hear that testimony. And they are going to be confronted with remember, what is the key to the state's case? Yes, they have circumstantial evidence, and it's powerful circumstantial evidence. And I would say, I'm not sure what happened here, but Macaulay is guilty of something, right? It seems pretty clear. These three guys, they were involved in this drug deal. Macaulay got this text. If I had to say, my theory of what happened in this case is Macaulay got this message from Carlos. He freaked out. He called the Demblain brothers, who were much more sophisticated than he was and much more involved in the drug business than he was. And he said, this guy's going to turn us in. What do we do? And I think they said, we'll take care of it. And I think the two of them went over there, and I think Christian did exactly what he said he did, and he killed these two people so that they wouldn't be able to testify against them. And then when the heat was on, they said, let's just pin it on him. And now Adrian comes in, and he gives this statement about everything that happened that day and how he saw it happen. And that statement, we talked about this last time, is so important for the prosecution's case because it ties everything together. He's the direct evidence. He's that eyewitness everybody wants. He's the one who gives all the circumstantial evidence its structure and says, this is how it happened. He is now, how credible is he? Not only did he get a deal in which he got 10 years for a double murder he was involved in, of which he won't serve much. But, oh, by the way, his twin brother confessed to somebody else that he did it and that he was just framing Macaulay for him. His credibility is completely shot. It's completely shot if that statement comes in. So I don't know what's going to happen when they retry this case. And my concern is that at the end of the day, you may have a circumstance where nobody ever really gets convicted for this. Macaulay will be convicted for something. He'll be convicted for some drug counts, maybe accessory to murder, but I don't know that anyone at the end of the day will be convicted of the double homicide of Carlos and Tara.
That was a good theory, Brett. And I think that's right, that this happens often, and that's why they're the lesser included charges, because Macaulay did something, right? He's culpable for something, but I think it's going to be a brand new trial, and I wonder what the state's tactic is going to be. Maybe if they actually have this trial, we can do a follow-up.
Yeah, we'll have to have a follow-up. If I were them, I'd be making some deals to make this go away. The articles I read said that the Attorney General's office was still trying to decide who was going to handle this. I kind of wonder if it's going to be the same prosecutors who did it originally or not. But
I think it would be difficult just because those prosecutors kind of got a slap down in the appellate court. There's kind of the appearance, if it's the same, it should be the same judge, but the optics are not great for the prosecutors who were called out in the opinion.
Well, we definitely will keep you guys up to date on what happens in this case and how it turns out. As we stand, we're still awaiting some of that clarity. We will put the appellate opinion on our website so you guys can check that out. You can read all about it and see how the court reached the decision it reached. It's a long opinion, but it's pretty good. There's a lot of Florida state stuff in there that doesn't really make any sense, but for the most part, the sort of the big picture, I think you can really get an understanding of how the court reached that conclusion. Well, so excited to hear what you guys think. If you have any other questions about hearsay, there's so many interesting ones. The dying declaration. That's one of my favorites. The dying declaration. The person's like, they're dying. And, their last words are,
"It was Billy."
Or, my husband is embezzling from his company or whatever. And then they recover and they don't die. You still can bring that in because they thought they were dying at the time. So if you think you're dying, whatever you say, like we've said before, you're not going to go to the gates of heaven with a lie on your lips. So whatever those last words you say, it's going to be believed. So if you're ever in a situation where you're about to die and you really want to stick it to somebody, that's the time to do it because everybody's going to believe whatever you say. But there's a lot of great exceptions.
Maybe we'll do a get vocal. Maybe we'll just do a get vocal where we'll read the federal rules of evidence of all the exceptions there are to hearsay. It will be so
It would take like an hour.
I
There are so many. I mean, it's crazy. I mean, you guys, we've told you that there are like 1,000 exceptions, and there are. It's just exception after exception after exception. And it gets confusing at some point because they all sound, the same.
By the way, I set it up. My
You set what
microphone
up?
stand. My microphone stand. I'm
congratulations.
so proud. Okay, sorry, keep going.
Yeah, so like the first three: present sense impression, excited utterance, then existing mental, emotional, or physical condition. It's like, what's the difference between a present sense impression and a then existing mental, emotional, or physical condition? And there is a difference. And but your mind just melts when you're trying to consider what all these are. Anyways, well, we won't bore you anymore with hearsay. But if you have questions about hearsay, feel free to shoot us an email, prosecutorspod@gmail.com. Reach out to us on Twitter, Facebook, Instagram. We're on Patreon, of course. If you're listening to us there in this ad-free episode, I hope you're enjoying it. We're also on YouTube. Give us a thumbs up. Give us a like. Hit that subscribe button. Leave us a 5-star review on Apple. Got to go run through all the business things here at the end. And we love hearing from you guys. Thank you to all of you who've reached out. And please keep telling your friends about the show. Well, Alice, do you have anything else to say before we wrap this one up?
No, but this was a really interesting case. From the beginning, it sounded like it was completely straightforward. But as usual, we brought you through the trial and hope you learned something along the way.
Yeah, the Law Nerd stuff's fun. So, or at least I enjoyed it. Hopefully you guys did too. If we see a massive drop-off in downloads after this, then we'll know that it didn't work out. But we'll be back next week with maybe less nerdy, but just as exciting case. But until then, I'm Brett.
And I'm Alice.
And we are the Prosecutors. You got it, Alice. I believe you.
I really don't, but I appreciate it. I'm just trying to get my microphone back to where it was before. But I forgot how I put it together. I'm a mess.
You're not a mess.
No, I am. But thank you.
We unscrewed the bottom of it. So.
Oh,
You got
that.
it.
Yeah.
Yeah.
You can go though.
What am I going to go and do?
Start recording.
I can't do this without you.
I'm right here. No, it's recording. Like, go.
Yeah, but are you going to be ready to go after I introduce you?
That's a good question.
That's the problem. You see the issue.
Yeah, I see the issue. No! Okay, wait. It's on a stand.